Today I will tell you about religion based marriage law in India. Hindu marriage. Hindu law of marriage and divorce is provided in the Hindu Marriage Act 1955. Although Hindu marriages are considered a sacred union, yet contractual features are incorporated in the law. Besides providing for rules for entering into the marriage, the law also the law also enables both husband and wife to put an end to their marriage in certain situations. The Hindu Marriage Act 1955 becomes applicable where the bride and groom are either Hindus, Buddhists, Sikhs, or Jain. It requires strict monogamy to be followed. Marriage with only one person at a time. If an already married person if an already married person enters into a second marriage, the first spouse not being divorced or deceased, then such conduct is a punishable offense. The second marriage will also not be lawful. In order to get married, the bride and groom should complete the age of 18 and 21 years respectively and be mentally fit for such union. They should not be related to each other as against the rules. The law requires the couple to get married by performing their customary ceremonies such as taking 7 steps around the fire or tying of thali. Once married, the couple need to register their marriage in the office of the concerned sub-registrar. Further, if the parties to marriage are Sikhs, then the Anand Marriage Act of 1909 allowed them to enter the marital union as per the Sikh religious ceremony of Anand Karaj. Muslim Marriage Act. Muslim marriage rules are quite distinct from Hindu laws. Muslim law for marriage has its basis in Shariat. Here, marriage is in the nature of contract, and the bride and the groom can enter into various agreements as to their matrimonial rights and obligations. A lawful Muslim marriage act, a nikah, requires the groom to make his proposal of marriage. The proposal then needs to be accepted by a relative appointed on behalf of the bride. This is called hijab and qabul. Usually, the marriage is officiated by religious judges or qadis. The entire process of nikah should be performed in the same sitting, and there should not be any considerable lag between the proposal and its acceptation. The proposal of marriage needs to be accompanied by a consideration amount or any other property meher to be given by the groom to the bride. This is regarded as a mark of respect towards the wife and has legal recognition. Further, if the parties belong to Sunni school of Islam, then two male witnesses and one male witness should be present at the time of marriage nikah. The marriage the marriage contract nikahnaama should be signed by the groom, the qazi and the witness. Furthermore, the bride and groom are also required to be mentally fit and should not be related to each other as against the rules of consanguinity and affinity. They should have attained the age of puberty, which is generally accepted as 15 years, although a guardian can contract a marriage for a child below such age. Some of the detailed rules of marriage are different of Shias and Sunnis. Also, the rules of marriage are different in the case of males and females. A Muslim male can marry a non-Muslim woman who is Kitabiya believer of book such as a Christian or Jew, whereas a Muslim woman cannot marry a non-Muslim man without conversation. Further, a Muslim man is allowed to enter into polygamy while the same is prohibited for a Muslim woman.